If you would, state your name, who you're here representing, please, for the record.
Good afternoon, Mr. Chairman and member of the committee, Representative Canales. My name is Arif Panju. I'm an attorney at the Institute for Justice. This committee is to be commended for responding to the growing problem that civil forfeiture is presenting and the much-needed reform measures that we hope to see. At the Institute for Justice, we represent property owners that defend against civil forfeiture actions across the country, some of which were referenced today, like the Muskogee, Oklahoma recent case with the Christian Karen ban, or the Texas Supreme Court case that Representative Schaefer mentioned earlier, State of Texas versus 2004 Chevy Silverado, which I should add was an innocent owner case involving Harris County. The truck was not given back. The case had to go all the way up to the Texas Supreme Court, and they denied review at the very end. But really presented an issue for the legislature. And the comments will be brief, but I just want to highlight something, and that is at IJ we litigated a lot of forfeiture cases. We litigate eminent domain cases, so property rights is near and dear to our hearts. And we do a lot of original research because we have a unique line of sight to these things. So one of the things that we've produced most recently, the second edition of Policing for Profit, which evaluates every state's civil forfeiture laws and assigns a grade. And in that study, Texas earns a D+ for its forfeiture laws. There are 4 reasons for this. I'll just touch upon those 4 reasons and recommend something that might be done here. The first is that there's a very low bar for to forfeit property, and no conviction is required. As we know, people have talked about this. The most efficient reform is requiring a conviction before a forfeiture proceeding can take place. This effectively preserves criminal forfeiture, as you know, but eliminates civil forfeiture. New Mexico is an example of that. At the very other end of the spectrum, what the legislature could choose to do is increase the burden of proof that's on the government. Here in Texas, it's preponderance of the evidence. In Florida, it was clear and convincing, which is a step up. They've heightened it to beyond a reasonable doubt. That's one example. The second reason that Texas got a D+ in our report is that the protections for innocent third-party property owners are extremely poor. I know it was debated up here on the dais that the burden doesn't really rest with the innocent property owner. It absolutely does. If an innocent owner, someone that's not part of the act or omission that gave rise to the forfeiture, comes in and wants to claim their property, they have to satisfy that they are in no way connected to this. So they did not know about the alleged criminal act or even knew about it. In other words, they must prove a negative. And so the presumption of innocence is turned on its head. That absolutely has to get fixed. As I mentioned, the LLE case, which went up to the Texas Supreme Court, was an innocent owner case. An individual had sold his Chevy Silverado truck to someone else. There was a $2,300 balance or so remaining after several years of that person making payments on it. He had several DWIs. The car was seized. The owner of the truck, who still had the lien on it, wanted the truck back to either dispose of it or use it in another capacity. And Harris County wouldn't do that. So this went up to the Texas Supreme Court, where you have dissents from Justice Willett saying, you've got to fix this if we're not going to review this. But the reason I bring that up is just to shed some light on the scenario where the Harris County prosecutor noted that we just give the truck back. This was an innocent owner truck. The truck's not coming back, and they will litigate this as far as it needs to go, and as we did, because there was some constitutional questions we wanted to resolve. The third reason that Texas got a D+ is the profit incentive. Have you heard some folks say as much as 70% of proceeds from forfeitures go directly to law enforcement in most cases? Now, the profit incentive is at the heart of this. It's one of the most troubling aspects of modern civil asset forfeiture laws, and unlike most states, law enforcement in Texas can actually use this revenue to pay salaries. By contrast, many states place those proceeds in a general fund, as we mentioned just earlier. Now, the branch that exercises the police power should not be self-funding by exercising the police power. That's one problem. And the ability to self-fund by taking people's property using laws that, in our view, undermines the very property rights that are enshrined in the Texas Constitution itself undermines the effectiveness that we would expect from elected officials who are providing oversight, because they're not even appropriating the money back. It's being self-funded. So this gives rise to all sorts of manifestations that we wouldn't want to see, like self-militarization. I think one person that testified said, well, the priorities of the Commissioner's Court might be different than our priorities. I think that's the point, because those are elected. And that they would use forfeiture funds to buy things that weren't in the budget. Well, there is a risk then of self-militarization, and that's a problem. The other thing is that relying on the ethics of law enforcement and prosecution is not workable. if there's a financial profit incentive in place where the money can go directly to those very people who are exercising their ethical obligation. So there's a big tension there. The profit incentive can be easily fixed if the funds are placed in a general revenue fund, or even if it remains at the local level, that they be placed in a fund that is then appropriated by elected officials, but not self-appropriated, where there's a budget that's submitted and nothing else. Finally, the last thing is there's very little transparency. That's why Texas got a D+. And as we mentioned earlier, and as Chairman Hunter noted earlier, no one can look at a forfeiture report and tell you whether there was any conviction or any arrest tied to a specific forfeiture. And the idea that supplying that information will overwhelm people. I'll tell you this. In my separate capacity, I sit on the board of the Freedom of Information Foundation of Texas, the FOIFT. And I've never heard of anyone in the public complaining that they are overwhelmed by transparency. It makes no sense. And so the idea here is to simply ask law enforcement, when they put the sharing agreement together before they pursue the proceeds, to also fill out a piece of paper that says, here's the property, was there an arrest, was there a conviction, how was it disposed of, how much is it worth? It's very simple, it could fit on a piece of paper. And that transparency is another check, along with these other three things. So just in sum, the four areas that we feel are necessary for an effective, comprehensive reform measure here is requiring a conviction or significantly increasing the burden of proof on government before they can take property using the civil courts. Second, innocent property owners, third-party property owners should not bear the burden of proof in any scenario. Third, eliminate the profit incentive. It's really what's driving this, and what's driving the abuse of forfeiture or even the threat of abuse. And finally, reporting basic facts about each forfeiture should happen, period. And those are the four things. If there's any questions on the reforms that we're proposing or any cases we've been involved with or the Oklahoma case, I'm happy to share it. I will end with this note. In Oklahoma, in Muskogee, shortly after a reform effort for forfeiture reform, took place, shortly after that effort died, the manager of a Christian Karen band from Burma was driving back home through Muskogee to Dallas, where he was pulled over, and over $50,000 was taken. Now, they took the cash and asked him to follow the officer back to the station, where they proceeded to interrogate him for a long time, make calls to the band leader, and the band had broken up for a week. They were visiting the U.S. from Myanmar, and they were going to reconvene and finish their tour. And some of these envelopes carrying the cash had the seal of the very orphanage that was going to receive part of these proceeds. The rest was going to go to help Christian refugees in Myanmar, which is a military dictatorship until pretty recently. None of this convinced law enforcement that they should not take the cash. They took the cash. Property owner went home in Dallas. A few days later, again, this is against the backdrop of there's no problems here. We should not reform forfeiture in Oklahoma in this case. A few days later, there's an arrest warrant for the band manager, the guy who was carrying the money and was basically managing this tour. Now, about a week and a half later, when we represented the band manager, members of the band itself, a church in Nebraska which was sponsoring all of this. The moment we filed that suit, within 8 hours, not only was the arrest warrant just gone, there was no more arrest. The cash, we were being asked who to make the check to so they can immediately return the money. And the reason I share this anecdote, it's because transparency brings a very strong check on abuse of forfeiture. But the Muskogee case shows that even after thorough investigation, detaining someone, taking their money, the idea that you're going to try to arrest someone for money laundering after the fact later on, to us, screams of an attempt to have a bargaining chip to try to negotiate with later on. And this points to a systemic problem with civil asset forfeiture laws, not only in states across the country, but also in Texas. So although we don't have such a big anecdote like the Oklahoma Muskogee case to talk about now, Tahana is just a great example of it. And those systemic issues are persisting here. And we'd ask that you continue squarely focusing on those things, because you have been doing that.
Right. Well, thank you so much for your testimony. Representative Canales.
I just recently read, you correct me if I'm wrong, you probably know a little bit more about it, a United States Supreme Court case where they'd seized some money, but the court invalidated that because they said that the dog that had done the open-air sniff was 7 minutes after the ticket. You're familiar with this?
I loosely am familiar with it.
And what the Supreme Court said in that case is that because the ticket had already been issued law enforcement could not hold him for any time beyond that. And their opinion was saying, you're not in the business of seizing money. You're in the business of enforcing traffic laws, and keeping people safe. And so that was held illegal. And I think that that's something that kind of falls in line with what you're saying, is that it's not a business, and it seems to be one.
It definitely creates a perverse incentive. And I think if you'd remove that financial incentive, the profit incentive, the systemic change would be a refocusing on other activities. I know too many people that have been asked how much cash they're carrying in the car after they get pulled over. There's no reason for that. And I think one of the reasons that that is the case is because there is an incentive. Now, it doesn't mean that folks are not ethical when they carry those duties as law enforcement officers, but I do think the systemic framework that they operate within creates some incentives that are misaligning the objectives that we'd want from a policy standpoint to be executed.
Thank you.
Thank you.
At this time, Chair will call